Thank you for coming to this session on intellectual property. Great to be Forgotten is in the room next door, and while that's very racy, this was where it all began, so it'll be very interesting to hear the panelists' insights. We have Ben Sheffner, who is the Vice President for Legal Affairs for the Motion Picture Association of America and a real expert on copyright law. We have Corynne McSherry sitting next to him, the Legal Director for the EFF. She recently filed an amicus in the Echostack case in Canada and is a real thinker on balanced copyright. Then we have Alex Feerst. Alex is Senior Counsel at Medium and also a CIS affiliate and maybe one of our most literary attendees at this particular conference. And we have Anne-Marie Bridey, a professor of law at the University of Idaho, also a CIS affiliate scholar, and just a really great academic on these issues. So I'm looking forward to hearing what everybody has to say. I'm going to remind the panelists that while each other's talking, you are to be thinking about a question to ask one of the other panelists for the time that you're done. Everybody will have 7 minutes to talk, and I will be doing the timekeeping, so just glance over at me when you have a chance. And Ben will be going first. Thank you, Ben.
Good afternoon, everyone. I'm Ben Sheffner with the Motion Picture Association, and thank you very much for having me. What I'm going to do today is set up a case that I think raises a lot of the issues that we've been talking about in this and various panels, called the Echostack case, which you heard referred to earlier up in Canada, where it's currently pending in the Canadian Supreme Court. So what I'm going to do is sort of lay out the basic facts and the issues, give a little bit of the perspective of the companies that we represent and our allies among motion picture producers worldwide. Then I'm going to turn it over to Corynne McSherry, who's going to give perspective of EFF and some of their allies, and hopefully give us a little grist for discussion a little bit later. So the case, and I'm going to refer to it as Echostack versus Datalink. That's not actually the name of in the caption. The actual caption is Echostack versus a guy named Morgan Jack and a bunch of other of the principals of the defendant, Datalink. So Echostack is a small business in British Columbia. It manufactures networking equipment, basically allows sort of B2B communication between different sort of industrial equipment. Datalink was a distributor. The allegation is that some of Datalink's principals is conspired with Echostack's former employees to steal trade secrets and basically make infringing products. So Echostack sued Datalink for trade secret misappropriation as well as trademark infringement and started to litigate in the courts in British Columbia. I think relatively early in the litigation, the defendants essentially absconded. They refused to participate in the litigation, and Echostack says they don't even know where the company or the people who were running it are. So essentially, as a litigation sanction, the court struck all of the defendants' defenses and sort of gave a default victory to Echostack. So Echostack went into court and essentially asked for orders barring the defendants from using any of the misappropriated trade secrets or selling any competing products that incorporated the trade secrets. But again, the problem was no one knows where these people are. Nonetheless, they kept on selling. They would, from various websites, again, no one knows or is quite sure where they're running them from, but through various websites selling the infringing products. They were actually held in contempt, and there's actually a pending arrest warrant existing against one of the defendants' principals. So Datalink, they have these nice court orders from the lower court in British Columbia, but they're doing them absolutely no good because they can't find the defendants. And they say this: they don't know where the defendants are, they can't possibly take any further steps directly against them. Their only realistic remaining option is to engage the assistance of Google, the dominant search engine conduit through which Datalinks, the Datalink defendants' websites were made accessible to the public. So first they went to Google and asked for sort of voluntary compliance. They said, Google, will you please stop listing search results for these specific websites? And Google said, no, that's, as a matter of policy, we don't do that. We do not delist entire websites. So Echostack went back into court. They obtained another order barring Datalink from carrying on any business on the internet. And Google at this point agreed to de-index individual URLs that would be provided by Echostack, but they would still, again, would not delist or de-index the entire sites. And at least as to when one of the briefs was written, Google had removed 345 individual URLs. Echostack says, you know what, this isn't good enough. These things keep on popping back up. As soon as we take down one URL, one or more keep on coming back up. So we're going to go back to the district court and ask for an order ordering Google, which again was not a party to the case, to de-index entire sites that are being run by the defendants through which their infringing products were made available. And the lower court made the following findings. I'm not going to read them all, but they sound a lot like the kinds of findings that would be made by a court here in the US in issuing an injunction. Again, Google itself, not a defendant, but the court did find that they were, quote, inadvertently facilitating the harm caused by the defendants through its search engines. This case is now on appeal. The intermediate appellate court essentially affirmed the lower court's ruling, and it's now on appeal to the Supreme Court of Canada. And Google makes essentially three arguments. One, they say that this order that commands them to de-index, and again, it's not just, I should have mentioned before, not just google.ca, the Canadian-specific website, but on all of their platforms, including google.com. So Google's first argument is this is a violation of freedom of expression. We're a search engine. Search engines are subject to the equivalent of First Amendment rights in Canada, and all we're doing is telling people where stuff exists on the internet. You shouldn't bar this form of speech. Two, they say they're not a party, and under sort of Canadian jurisprudence, you shouldn't be able to bind a non-party through this kind of order. And then lastly, they say that it violates principles of international comedy, essentially that by a Canadian court ordering all of Google's platforms, which are of course available worldwide, not to engage in this form of communication or this form of speech, as Google would characterize it, you are essentially imposing Canadian law on the entire world, and that violates principles of comedy. Just to wrap up, FIOP is the French acronym for essentially an association, umbrella association of film producers around the world. This case has actually attracted a wide array of essentially what are called amicus briefs. They're called interveners in the Canadian system on both sides. Corynne will tell you about EFF and a lot of their allied groups talking about, from their perspective, what a mistake this form of order is. But from rights owners' perspectives, even though this is a trade secrets case, which is not a sort of a form of IP that we normally care too much about, the principle of a court being able to enforce the rule of law on the internet is very important to us, and we try to lay out some principles that we think a court should take into consideration when granting an order against a non-party internet intermediary that may be facilitating tortious behavior when the defendants themselves are not complying with the order. And these are the four factors that we said the court should take into account. One, the likely effectiveness of the order, and we're careful not to say that the order would have to by itself, or the defendant by itself, would be able to stop the tortious activity, but that it would have a significant impact in reducing the tortious activity. Two, the cost to an intermediary of implementing the order. Three, and we agree, I think, with those on the other side, that the impact on freedom of expression is important. And four, the evidence that the order will have extraterritorial effect in a manner that offends comedy. And just to wrap up in 30 seconds or so, in the description of the panel, one of the questions was, well, is IP different? And one of my arguments up here today will be that, yes, it is. We talked a little bit about this in the first panel. I am certainly not going to be here to defend a Turkish court issuing an order to Google to remove blasphemous material worldwide, or for China to issue an order, if they even have jurisdiction over Google, to take down something that was critical of the Chinese government. There are vastly different legal regimes all over the world covering things like blasphemy or defamation, privacy, etc. IP is different, especially copyright is different. There are over 170 countries have signed on to the Berne Convention, which is largely harmonized copyright law. And we're not talking here about difficult issues of copyright law about, is this a close case of fair use or not? We're talking about the kinds of orders that would issue in the copyright context are really against websites that are blatantly infringing, that do nothing but offer full copies of movies and television shows, et cetera. And again, we don't think it offends notions of international comedy for a court to issue an order that may have worldwide effect. So with that, I'm going to turn it over to Corynne. She's going to give her perspective, and then hopefully we'll have some time for discussion in a few minutes.
Okay, and just so you guys know, in terms of a plan for the panel, we're not going to talk all about the Echostack case. We just, it's such a hot issue right now, and many of us have just recently been writing briefs about it and thinking about it, and it really did seem to raise a lot of the issues. So we're going to talk about the Echostack case, but then also Alex and Anne-Marie are going to talk about some other issues so that we can, get the full picture. Echostack is just really interesting because it really seems to hit on one particular piece of this, which is when you have a court order. And I think we already saw this morning, there are lots of different ways in which internet jurisdiction problems arise. They can arise in the context of individual policies, they can arise in the context of government regulation, but also they can arise in the context of a court order. And so that's what I think the Echostack case can raise for us that I think is interesting. So thank you, Ben, for saving me the time of explaining all the facts. We can move on to where we had concerns. So EFF, the Electronic Frontier Foundation, where I work, but also a number of other public interest groups around the world, Human Rights Watch, Article 19, we all filed briefs, and we would understand them as amicus briefs, but they call them interveners there, one of the many wonders of Canadian law that I've been learning all about. So we filed a case. We filed actually in the appellate court as well, and then we also filed before the Supreme Court. And the concerns that I think all of these groups have sort of boil down to three. One is there's sort of, it seems to me, a fundamental due process problem when you have a court in one jurisdiction issuing an order that is going to affect citizens around the world by a delisting order that is going to limit citizens' access to information. And and many countries have this kind of fundamental notion of due process, which is the legitimacy of the rule of law it derives from the fact that it's with the consent of the governed. But when you have a court issuing an order based on just that country's law, then you're affecting people in other countries where they don't have notice of or even the ability to change that law, to affect that law, right? They have no control over it, but nonetheless, it's going to impact them. So that's kind of a due process concern that we have. The other concern is, of course, the free expression concerns. Now, Google raised its own, speech arguments in its briefing, but our focus was actually less on that, less on Google's speech, and more on the fact that users' rights, because we have a right to information that's protected at least in the United States, which is how our brief was focused. And we have all kinds of protections in our law in the United States for that right of access to information that this Canadian court doesn't need to think about, or didn't seem to think it needed to think about when it issued the order. That's a concern for us. We have a fundamental inconsistency between the law of the country that's issuing the order and the law of many countries, but just focusing on the United States, where that order is going to take effect, right? So here we have First Amendment protections, we have CDA 230, we have all these ways in which we try to ensure wide and varied and robust access to speech that we think is actually kind of the cornerstone of the internet. But the Canadian court doesn't care about CDA 230. Why should they care about CDA 230? That's not their law, right? But it is ours. And citizens of the United States, we are concerned about protecting it, and there's no ability to do that. So we focused a lot on user access to information, and I think it's a really important concern, especially, and let's be clear, this is just one dinky little trade secret case. Why is everyone and their mother filing? Not because we care about this dinky little trade secret case, but because we care about the precedent that it might set, right? And it's ironic enough, I think it's easy to sort of point fingers at Turkey or countries where they have regimes that we don't like. These are the nice Canadians. Everybody loves the Canadians. But the Canadians are the one who are going to issue this order that's going to set potentially a very dangerous precedent. And that relates to sort of the final thing, which is, though, the race to the bottom that we worry about. So it starts in Canada, but where does it end up, right? And what we worry about, that's the other part of the precedent, is a situation where we have effectively some species of forum shopping. So if you want content taken offline for whatever reason, pick your court, pick your jurisdiction, and see if you can jigger up a case there. We see forum shopping within the United States all the time. If you are resourced enough, then we can see that kind of forum shopping happening internationally. So those were our sort of principal concerns. And I realize I've taken too long. So what should we do about this? So EFF made a proposal. How do we think about these extraterritorial orders, short of just saying that we're going to ban them altogether? We're going to say a court can't do it. So we tried to figure out what would be a standard that would work. And so our sort of rubric is, would the order offend a state's core values, where it would be a state that it would affect? Has the plaintiff made a strong prima facie case? And the reason this is important is that often these kinds of orders are going to come up in a context where maybe the defendant has disappeared. The defendant is not making the strong sort of fundamental underlying case on the merits. And in that context, you want to ask the plaintiff to do that if you're going to have an order that's going to affect non-parties. What's the level of harm that we're talking about? Is the order narrowly tailored to addressing that harm? Is it technically feasible and effective? A court should think about this and allow the non-parties who are affected to have a chance to weigh in on it. And then just a sort of basic balance of equities question. Human Rights Watch in Article 19 made a somewhat similar proposal that I wanted to just refer to as well, because it overlaps a little bit. And their proposal is derived from the International Covenant on Civil and Political Rights. So they said, well, first of all, is the order valid under domestic law? Well, that seems pretty basic. It better be. Is the order necessary to protect rights, national security, public order, public health, or morals? Again, this comes from the ICCPR. And finally, is the order proportional? There you're asking things like, is it overbroad? Really, I think it's a way of thinking, is it narrowly tailored to actually addressing the harm it's supposed to address? So I'll close with that, but I do think that it's important for us, and it would be nice if we could get a sort of emerging international consensus about how we are going to think about these extraterritorial orders, because we're going to see cases like this over and over, I expect. And we need some kind of framework for thinking about them, short of just eliminate. I mean, my druthers, we wouldn't have these at all. But if we're going to have them, we should have a very stringent test for when they're acceptable and when they're not. Thank you.
Slides to get through, and I will try to move quickly and respect the timekeeper. So this project is actually a continuation of work I've been doing over the last several years on the evolution of anti-piracy practices and the private ordering of online copyright enforcement, right? So I guess my question for everybody following our discussion of Equus Neck is,
Can you make sure to talk to the...
Sure. So what if the jurisdiction of courts over non-party intermediaries could be made irrelevant to anti-piracy enforcement, right? What if right holders could get the keepers of the domain name system to start policing content on websites and unilaterally suspending or canceling domain names in response to their complaints, right? What if there were a DMCA style notice and takedown system for entire second level domains, right? And here we get to questions that we were talking about in the plenary panel from this morning about what the boundaries are between governance of the internet and governance on the internet, right? So for trademark rights, enforcement in the DNS is nothing new, right? So the ACPA, the Anti-Cyber Squatting Consumer Protection Act, and the Uniform Dispute Resolution Program were both in existence prior to the turn of the century, right? So the DNS is a logical, maybe necessary field for trademark enforcement because domain names frequently incorporate word marks, right? Because the asserted IP right inheres in the domain name, adjudicating trademark rights in domain names doesn't really require any or much assessment of the underlying content available at the website. And this, I think, is a critical difference between trademark and copyright enforcement through the domain name system, right? So enforcing copyrights through the DNS is a more recent phenomenon and one that right holders like because it enables cross-border enforcement, right? So the first major development in this space was the Pro-IP Act of 2008, which became the basis for government seizures of thousands of domain names between 2010 and 2012. In 2011, of course, there was SOPA, which almost provided for court-ordered site blocking by DNS intermediaries. Over the last 2 years, courts in civil pirate site cases involving extraterritorial defendants have been asked to grant and have been granting site blocking injunctions against US-based non-party DNS providers, right? So as of last March, and this is what I'm going to be focusing on for the rest of this presentation, the ink was dry on the first voluntary enforcement agreement between the MPAA and Donuts, which is the Seattle-based registry operator that controls hundreds of new generic top-level domains. And that agreement was quickly followed by an agreement with an Abu Dhabi-based registry operator called Radix, between Radix or Radix and MPAA. So the backstory on the MPAA Donuts agreement begins with ICANN's launch in 2011 of a substantial expansion of the internet's namespace through the introduction of over 1,000 new GTLDs. Right holders saw in the new GTLD process an opportunity to inject copyright-related obligations into the hierarchy of private ordering agreements governing the relationship between ICANN and the various downstream entities that administer the DNS, so registries and registrars. Okay, so not surprisingly, the music and movie industries have been the most active among right holder groups in lobbying ICANN for copyright enforcement in the new GTLDs. So here's a letter from last year from the RIAA's General Counsel to senior ICANN officials demanding increased commitments for copyright enforcement in the new GTLDs that target music or digital content. And then here's an MPAA policy blog post also from last year praising the 2013 version of the ICANN Registrar Accreditation Agreement for requiring all accredited registrars to implement a notice and action protocol for dealing with complaints of IP infringement. Right, and so the fruit of all this activism within ICANN is a flow-down provision in the ICANN registry agreement that requires registries to include in their contracts with registrars a provision that requires registrars to include in their contracts with registrants a provision that prohibits copyright infringement and promises consequences for infringement, including suspension of the domain name. Right, so since 2013, registrars have agreed as a condition of ICANN accreditation that they will provide a notice and action protocol to deal with complaints of illegal activity, okay, presumably including copyright infringement, right? So this provision includes a duty to investigate and, quote, respond appropriately, unquote, to complaints. As I think Bertrand alluded to earlier this morning, there's a huge amount of controversy going on right now within ICANN over what it means for a registrar to respond appropriately to a complaint from a right holder, right? So some believe that it's appropriate to just say, well, if you have a complaint, go get a court order and bring us a court order and we'll do what you're asking. So complainants who believe a registrar is not honoring its contractual obligations can seek redress from ICANN through ICANN's contractual compliance process by completing a simple online form, right? But ICANN's current position is that the contractual compliance process is not a mechanism for punishing registrars for failing to suspend domain names in response to right holder complaints. Okay, so that brings us to the MPAA Donuts agreement. So there's all this controversy now roiling within ICANN over exactly what these flowdown provisions mean, whether the registrars and the registry operators have to do more than simply include them in their contracts, whether they actually have to enforce them, whether enforcement means that they have to respond to complaints from right holders. So all of that's going on. But then we have donuts, which is, I think, more agreeable than some of the other intermediaries have been. And so we get a voluntary agreement between them. So donuts, just for your information, is the operator of .movie, .wine, and .computer, right? So obviously the MPAA is interested in the .movie generic top-level domain, among others. I mean, the agreement here is facilitated basically by the contractual infrastructure that I just described, right? So when you have a willing registry or registry operator, the agreement can happen voluntarily and there's no element of compulsion. So what does it do? So the agreement creates a trusted notifier program in which Donuts agrees to treat MPAA's complaints expeditiously and with a presumption of credibility. Right, a predecessor program that gives special treatment to notices from qualified senders, for those of you who work in this space, is Google's trusted copyright removal program for search, and I think that program is being now expanded into other areas. So the standard for the submission of a complaint is clear and pervasive copyright infringement. Before approaching the registry, MPAA has to first go to the registrar of record and the site's hosting provider. The complaint has to contain a DMCA-like statement of good faith belief that the site is being used to infringe copyrights. Finally, the MPAA has to confirm that the complaint results from careful human review, right? So in other words, no robo-notices. And this provision should, I think, and is likely intended to limit the volume of notices processed under the program. So my time is up, but like Corynne, I'll just raise some of the normative concerns that I have about this development, right? We have a presumption of guilt for accused registrants. The complaints target and sanctions affect an entire domain rather than specific content, right? So we're talking about sort of suspending or canceling entire second-level domains. No requirement for the MPAA to attempt to contract the registrant. Lack of clarity about what constitutes clear and pervasive copyright infringement, lack of clarity about what constitutes careful human review, lack of procedures for registrants to contest complaints or appeal sanctions, and finally, a lack of transparency about the sanctions that are taken under the agreement and no mechanism for any kind of systematic public reporting about what sites are being disappeared because of these complaints. So that's it, thanks.
Hi, everyone. It's good to be here with this esteemed group of co-panelists. Anne-Marie and I are among the small group of, I think, literary theorists who have sought our revenge as copyright lawyers. So, glad to be here. I come here not with any grand theories, but with two related small problems I want to pose that are really gripes more than problems. And they are both ripped from my email on Friday, which I'm not seeing here, so I'll just tell you about it. The two related problems are this. Problem one, I'm calling DMCA for everyone, sort of. And then problem two is the help desk archipelago. So on Friday, and this is a public DMCA notice, we got a DMCA notice from the government of Ecuador. They, unlike the US government, feel that in order to incentivize government photographers to do their work, they need copyright. Pete Souza's tendency to put Creative Commons licenses on his photos notwithstanding. So we got a takedown of what looks like pretty fair usey stuff to me, although it's not my job to say. It's a Ecuadorian publication that publishes on Medium. They write political things and other forms of news, and they use photographs to depict some of the politicians and other public figures. And those photographs are taken by the Ecuadorian government. They sent us a takedown, but not really. So I think question one, which isn't exactly applied to this case, but a general thing that occurs, and I say this as a sort of ditch digger in the DMCA trenches, is that you get DMCA notices from all over the world now. And that's fine, I think, under the treaty regime. But a question is, there are a couple of holes that I think about sometimes, and I sort of wonder what Fred has thought about these things. And one of them is that you consent to jurisdiction as a counter-noticer, but you don't consent to jurisdiction as a noticer. So when you send the notice with the knowledge that most things get taken down after a notice, and very few of them ever counter-noticed or restored, it's unclear what you are really consenting or agreeing to do. Because if you get counter-noticed and it does get restored, thing one is that it's unclear that you have ever agreed to sue in a US court or to be declaratory judgment did in a US court. And thing two is that it's unclear that you've waived your remedies in whatever country you're in the first place. So having restored that material, I'm not sure what people are purporting to do when they send a DMCA notice to based on a foreign work, because they haven't necessarily waived any of their rights. And I don't know if I want to go to a court in Ecuador or Turkey or Venezuela or whatever with a DMCA notice that says this has an electronic signature on it. Surely they waived all of their rights as an Ecuadorian citizen or as the Ecuadorian government by sending this DMCA notice. And if they haven't done that, then why do they get 2 bites of the apple? And these are the things that I sort of wonder about. And I guess what I'm saying with this is that we have a sort of de facto, non-harmonized, non-thought-through global regime, and it is sort of called DMCA for everyone, sort of. And there are probably other problems, but those are the 2 biggest holes that concern me when these things come in. The second thing is what I said is calling the help desk archipelago or the CDN archipelago, which is this. I haven't looked at the Gartner reports recently, and I'm not an expert, but I think that this cloud thing is going to be big. For those of us like Medium, I work at Medium. We're a small blogging company with big ideas. We don't have our own data centers like Google or others. We rent them from AWS, and with the exception of Google Cloud, CDN, Microsoft Azure, and these folks, most of us are renting a server space, and we are renting cloud, and we are also using their CDNs, AWS, Akamai, Cloudflare. We are also hosting our entire site on AWS. That's the whole ballgame. So when we get a DMCA notice that is sent to our CDN, which is AWS, which is what occurred on Friday, it is, number one, unclear what Amazon's position is. So the various CDNs might take different positions as to which of 512A, B, or C they are. And they don't necessarily say that, but it's unclear. We are a user of Amazon Cloud Services, so in some sense, it may be that we are a downstream 512C provider of another 512C provider with rolling obligations. Another word we have for this in Medium legal department is this is like bizarro Creative Commons. It's like the regime where everything clamps down more on the thing that goes downstream to it. So if we receive a notice from Amazon, and we have, it says, you have 24 hours to deal with this. There's a bunch of images of Ecuadorian government officials that the Ecuadorian government says shouldn't be up on the internet because they're infringing copyright and the necessity of Ecuadorian photographers to be creative. If you don't take it down in 24 hours, you will have a problem. And for us, that problem is that the whole site comes down potentially because, as I said, we are renting our server space. And I should say here that it seems to me that the whole cloud becoming big thing is that more and more of the internet is going to be abstracted and localized on other people's servers, OPS. Very few of us are going to own data centers in the future. It's going to be like the big four, whatever, Azure and Google, AWS. So entire sites can be taken down not by a legal regime, not by a complex determination based on principles of comedy, not by a reasoned determination, but by a help desk ticket, which I respond to and I say, please don't shut down our whole site. Let me figure out the 512C analysis and talk to our user. I then talk to our user. They are downstream further, try to get some word from them. Do they want to counter notice us? Do we counter notice AWS on behalf of the counter noticee? None of this is really legally determined territory. And the risk calculus is, and I know if Paul were here, he would say the answer is have a backbone and tell them to go away. And I think that that's a perfectly fine answer depending on the size of your backbone, but the answer is saying no to the help desk attendant is essentially risking pulling your whole site down in 24 hours. It's a frightening determination to have to make when you're trying to run a reasonable and compliant DMCA program. So these are the 2 points that I have to make, and I guess the first one to sum up is if the DMCA is going to, by default, like English is the lingua franca, a type of regime that people are satisfied with, there are many aspects of it that are not thought through, including fair use, including these holes in consent to jurisdiction and the practicality of counter notices and what they actually accomplish. And I don't necessarily propose that we can purport to impose these on the rest of the world, that we can purport to force people to consent to them. But as it is now, the holes are tremendous and troubling, I think. And the second point is that the chain of contractual relationships that exist and will continue to proliferate, the CDN level, the DNS level, have to do with contractual risk-based analyses of how a counterparty might behave, where they have tremendous amounts of leverage over whether or not you will exist, whether or not your site will resolve, things like that. And for me, as a practical matter, as I said, as a ditch digger in the DMCA trenches, these problems eclipse a lot of the larger issues about international comedy and some of these other theoretical matters. So I leave it to you.
Okay, so now I'm going to let you each ask a question of the other. So, Ben, would you like to go first?
Sure. So let me direct this at Corynne, since we both talked about the Echostack case. And one of the things that one of the concerns you raised about the court's order in British Columbia was, and hopefully I wrote this down correctly, is that quote the order quote affects citizens around the world, and that was a concern to you. I'm going to just push back on this a little bit and ask for your response. I mean, that seems to be at first, oh yes, that's very concerning. Why should some little court in British Columbia get to impose its rules around the world? Thinking about it a little bit harder though, is that really so new? Let's say this case was filed back in, say, 1992, before the pervasiveness of the internet, and it was a trade secrets case about this little, defendant who operated out of a warehouse somewhere in the outskirts of Vancouver, but they were nonetheless shipping their stuff, their products, their infringing products around the world. And people in Ecuador and France and Saudi Arabia relied on them every day. And then there's a case in court in British Columbia, and the court says, you know what, these things are infringing. They're blatantly infringing. These guys stole the trade secrets, not even a question. I'm going to issue an order shutting you guys down and forbidding you from shipping your stuff anywhere to anybody. That, of course, affects the people in British Columbia who may have bought these infringing products, but it also affects all these people around the world. I mean, would you consider that type of order, that type of pre-internet order, improper because it, quote, affected people around the world?
So I think that a fundamental distinction, and this is kind of in some ways why we're all here today, is because we're not talking about the pre-internet world. We're talking about the internet world. And what that means is that the kinds of effects that something can have isn't simply, can I buy a product or not, right? That's an effect that you might have had in 1992. But I think the effect that you have now is that you have effects on speech, which is sort of offending a more fundamental core value, which is why in our test we try to sort of speak to that. It's not just a question of, is it affecting somebody in another country, but do we have a clash between the core values of another country? And that's what I think got raised in the Echostack case. Because I think you're quite right, courts issue orders all the time that may ripple out in a few different ways, and maybe we don't have to worry about all of them. But I do think that when you're talking about many kinds of IP-related rights, and really this is where it hits copyright a lot, then you're going to be affecting speech, or trademarks, same thing. And I think those are the kinds of effects that we care about more and we should care about more. So I think that would be my thing. I wanted to speak to that other thing too, which I do think that it was a sort of key question of the panel, and I think it's an interesting and important one, which is there's something different about IP. And let's not talk about trade secrets, because that's a weird form of IP, and we dispute whether it is IP and whatever. But let's talk about copyright, right? Because Ben spoke to copyright. And there is a way in which there's some harmonization of copyright law around the world, many different countries. But the fundamental, there's also something that's where things are not harmonized, which is not everybody has fair use. And until the day when every country has fair use, I'm still going to have a problem with copyright-related takedowns. And the other thing but what is unique about IP, and we talk about this a lot in my office, it's only in copyright land that you can send an email and have speech taken off the internet. You can't do that with defamation claim. You can't do that with lots of different kinds of legal claims, but you can do that with copyright. That is unique, but unique in a way that I find troubling, but not everybody would. I have questions too, but, but thank you, that was a good question. So, would we want a world, I'll just pose this to the panel, would we want a world in which it is, DMCA for everyone? DMCA with a super strong 512F remedy to protect users. Because I actually had a case where this came up, which involved Professor Larry Lessig. He got a takedown notice from a small music label in Australia, and their argument was going to be, we're sending this from Australia. It's a DMCA notice, but we're sending it from Australia. Australia doesn't have fair use. We don't need to think about your stinking fair use rights. We would have argued, no, actually, if you invoke the DMCA, you're subject to its jurisdiction. Now, that case settled, unfortunately, but that's the argument we would have made. But would we want that? It sounds to me like maybe you wouldn't want that. I'll just start with you.
Sure.
Pick on you, but anybody can answer.
Yeah, I think that's right, in part because, number one, like when we talk about harmonized global regimes and things like this, I think what we also mean is like, I like ours,
Right, exactly.
Like as long
That's
as we
the problem.
harmonize to exactly where I live, it would be awesome. So when we are realistic, in my rudimentary and caveman level understanding of EU law is that like the floors are sort of like tilty, and it's not really clear which of the various member states are doing things at different times. So I for one would not be happy with a global regime that was as harmonized as the European model of it. As to fair use and all these other things, leaving aside the question of whether people consent to fair use or whether there's some sort of like ported fair use that happens, it's also, if it is not part of like the indigenous norms of a place, and I think it's fair for some countries to say like, we don't have a free speech norm, we don't have a fair use norm, it's not a thing we care about, then why are we asking them to essentially, there is some sort of mild post-colonial exercise in what the DMCA will accomplish in this. And like I personally would be for my DMCA for everybody, but at the same time I recognize that like the request to harmonize in the name of efficiency and smoothness is gonna trample on a lot of different folks. And even though I've adverted to and made fun of like these weird aspects to me of countries with government copyright and no fair use and what those things accomplish in this type of scenario where it is clearly trying to censor newsworthiness, those things like offend an American sensibility, but they don't necessarily offend others, and I'm not sure we can ask them to harmonize to our way if they want to use the system. At the same time, I think as a practical matter, and I'll leave off there, is that folks know that if you use the DMCA, you have an extremely efficient mechanism to have folks like me look at the complaint or look at the notice, see if it's facially compliant, and then take the thing down, because that's sort of what we generally do. And that alone might be a benefit of the bargain for complying with all of our various fair use and other provisions, is the tremendous extrajudicial, they say, the ability to have something, maybe sinister, maybe not disappeared from the internet, is the efficiency that you buy with that.
So let me ask you a question. So the DMCA notice came from Australia, right? And so had Larry Lessig refused to take the content down, he was hosting the content himself?
No.
So
It was
how did
a
this go?
video on YouTube.
Okay,
It was
so-
a lecture about fair use.
Okay. And so,
You really couldn't make it up.
so I mean, so YouTube was taking it down, or,
Right.
okay. So then if Australia decides it's gonna sue, right, if the right holder in Australia decides it's gonna sue, where does it sue? It sues in US courts, right? I mean, you can't bring a sort of DMCA-based claim in Australian court. I'm just trying to sort through what the consequences would have been here for.
Well, we actually sued them,
Okay,
because it's a long story, but Professor Lessig did counter notice.
okay.
The video was restored, but nonetheless, we went after them under Section 512F, and we sued in a U.S. court. And, but the argument that would have been made by them is to say, well, fine, you could sue me in a U.S. court, but I don't have to, whatever considering fair use means under Lens versus Universal or
okay.
whatever, we don't have to do that because we're in Australia, right? And so we think that the law of our country governs this. We're affected in our country, right? And this is where you get these kind of thorny jurisdictional questions. I would have loved to litigate that case, but
Did they talk about bringing a parallel suit in Australia? Like,
they didn't get that far.
okay.
They folded like a wet blanket.
Because this is the stuff that concerns me, is sort of showing up in a foreign court with like some patchy emails and being like, they've waived it all. like all of their rights and all of your sovereignty. Like, I think that would essentially have to be the argument, and that seems crazy.
Because I mean, it is the flip of the due process concern that I was raising earlier, right? Like, and the DMCA is your option, though. What else are you gonna do? If you're in Ecuador and you see something and you want it taken down, this is the way you would do it. I mean, I would.
Well, since we're talking about Ecuador, I have a question for Alex. So I'm kind of, why didn't the government of Ecuador send, obviously you're not gonna be able to answer this question, but it's sort of a question for the cosmos. Like, why not send the takedown to Medium? Like, why does it go to Amazon?
Yeah, I mean, I assume that the government of Ecuador is familiar with Medium. Since, no, I mean, I think step one might be like they have no idea what Medium is. They saw a website and they sent it to, they found the images on a CDN. A more nuanced answer is actually, this is not a plug, but Medium has a thing called custom domains, wherein your own URL can resolve to a Medium page that is logged in. So if one goes to thinkprogress.org, which is a blog, you are actually on Medium nowadays. So it is not necessarily clear, if you are not a power user, as the Ecuadorian government is not, whether or not you're on Medium. So I think that was the issue. And I think they were trying to follow it upstream, doing, I think, some pretty technically savvy work to see exactly which, and they didn't just look at the CDN, they found which individual CDNs were serving up the images. And so I think that looks like, I assume that's like the CDN equivalent of follow the money trail, of being like, where is this hosted image being served up to us in Latin America?
Because I'm just trying to think about sort of the, the DMCA registered agent issues around that, right? And so it's like how, it's very, that's the customized hosting thing is interesting because it just makes it hard to know who you're supposed to reach out to when you find something that's infringing, right? Yeah.
Or like, and there are so many fun questions that Zach and I, the other half of Medium's legal department, talked about, such as like, what does like expeditiously squared mean? Like if you are going to have upstream and downstream running obligations where people are going to notice and counter notice and expeditiously do X, Y, and Z, stacked on top of the fact, as I said, that I wrote to the help desk folks and just said, like, could you chill while we resolve this and like not take everything down? And then we waited, I think we reached hour 18 or 19 and started to get a little bit nervous because they didn't write back. Because like, not to be that way, but like it's Amazon's help desk. It seems strange for so much to rely on whatever it is, a help desk next to the chickens. So I think the question of pushing to the level of architecture and like and moving, on the one hand, it seems sort of tempting to say like that's a good thing that people are finding where the actual image is located and they are trying to give a rigorous account of like what is the work that is identified and what they're doing with it. But at the same time, I guess the current ambiguity around what a CDN is and other things that are related to cloud architecture, I think are going to become just more and more problematic.
So in terms of your in terms of Medium's contractual arrangements, just to follow up with Amazon, like, does Amazon have the ability under its contracts with Medium to take Medium's stuff down? To take stuff that's hosted?
I don't know if I'll talk about the contract specifically, which I haven't actually memorized, but I would say that I think the calculus would sort of be like, we are going to comply and shift our liability because we got a valid DMCA notice. We are going to shut you down. We Medium are end-to-end encrypted, like many other things, so you cannot at other layers filter parts of the site out. This is why we get blocked in countries, because like lots of folks were end-to-end encrypted. So that's either it's an all or nothing proposition, and if for them, the difference between a tiny bit of liability and no liability, they're going to take the tiny bit, even if, as that relates to us on the other side of the seesaw, it's our entire site going down versus 7 maybe newsworthy images from some dude in Ecuador. So I think the internal leverage that occurs along these strings of contracts is not only very difficult in real time to sort of stake things on that. I think to me that is the real extrajudicial teeth of what happens, like aside from the legal determinations. Like extrajudicial determinations get made in 24 hours or less based on what somebody who's not a lawyer decides.
So I want to give the audience a chance to ask some questions, but Alex, you didn't get a chance to ask a question. So if you want to ask a short question, and then we'll take some comments from the audience. But let me also say the last panel of the day is going to address more in depth exactly that point raised about decisions within the company.
Yeah, cool. I'll yield my time to the floor.
Okay, thank you. Anybody want to come? There's a microphone. Please line up.
So on this notion that IP is different, I'm Fred von Lohman, by the way, from Google. I want to test this thought a bit with Ben. So let's imagine a situation, Ben, I'm sure you know that the Family Guy, the long-running primetime animated series, has been in a number of copyright scrapes, including winning a fair use case that was brought against its parent company, Disney, for using a song, I believe it was. And so let me see if I can spin a hypothetical here to test what you mean by IP is different. So let's imagine the songwriter, the rights holder, goes to court in France, where fair use is not a defense, and the French court says, oh yes, Family Guy, you're an infringer. And by the way, we are going to grant an injunction barring the Family Guy not only in France, but globally. So the Disney must cease immediately making it available anywhere on the planet. And moreover, we're going to make the injunction run against Netflix as well as a non-party, because they, of course, have episodes of the Family Guy on their service. So we are going to say they also must globally remove this content as well. Is it your view that that's all right, and that the motion picture industry would be comfortable with that kind of injunction?
I think probably not, and I think that's distinguishable from the Echostack case. I mean, as you describe it, that's a case where the answer might be different in France than it is in the US, where we have a robust fair use doctrine, we have First Amendment considerations that play in.
Right, but the answer would be the same almost everywhere in the world, right? The United States as a fair use jurisdiction is by far the outlier. So it's not entirely as different as you suggest.
But an important outlier, I would say. But again,
we think so. I agree with that.
we think again. I mean, one of the factors that we said that a court should take into consideration is these notions of international comedy. And when you have an important issue like that, where in one jurisdiction you're going to get one answer, in another jurisdiction you're going to get a different answer, especially in important jurisdictions like France and the US, that may not be a situation where you'd want a worldwide order. Again, I would point out that as far as I'm aware, in this case in Canada, this is not a situation where anybody, including Google, is arguing, hey, you know what, it may be illegal to sell these infringing products here in Canada, but you know what, it's totally fine in France, and how dare you deprive the French people of this valuable information and ability to get this product.
Right, but I think that exposes the core difference here, which is, it sounds to me like you're saying that you would be perfectly comfortable with a case-by-case analysis by every court in the world, applying your factors. Sometimes they'll come out a way you like, sometimes they'll come out a way you don't like, and there will be a global ban on a television show, a film, and you're okay with that being applied case by case, court by court, with global impact for free speech. And Google's position is that we don't think the global impact on speech is appropriate as something to be handled on a case by case, court by court, based on factors where they may come out one way, they may come out another way. It's a different question, of course. Nobody's disputing, and we certainly didn't dispute, that the Canadian court has jurisdiction to control Canada. But the issue is whether there's an ability to enjoin a non-party for global purposes. And as I said, it would be as though a court reached out and told Disney, you must never show this episode anywhere on the planet, and we can reach out and hit every distribution network that Disney uses and insist that they also not circulate or broadcast or transmit that content anywhere on the planet, just because in one country it was found to be unlawful.
Right. Well, and I know there's other people who want to ask questions, so let me just respond really briefly. Fred says, well, it's fine. We understand, Canadian courts have jurisdiction here in Canada. They can issue an order that just applies to Canadians. We all know that on the internet that's not simple. And Google did propose, well, okay, fine, maybe this will work as to google.ca, but we're certainly not going to touch google.com. Everyone knows, it's two letters different. It's very easily evadable, if that's a word. And the question is, okay, well, what's the alternative? The alternative is that when you have a defendant which completely flouts court orders, which flees the jurisdiction, which is, evading these contempt orders, do you just say, throw up your hands and say, you know what, it's too bad. The plaintiffs are right, the defendants are wrong. I'm going to issue an order, but there's just absolutely no way to enforce the rule of law anymore because we have this global internet. I don't think that's a viable alternative either. If you're a small company in British Columbia, you're out of luck.
The same as it's always.
Well, harder.
Hi, you all know me. Actually, I think everyone in the room knows me, but I'm Kathy Gellis, and I advocate for free speech interests in the context of platforms. So I wanted to raise a DMCA issue. As I was sitting there, this was all very interesting. It was really interesting to hear about the tensions that you're experiencing vis-a-vis the DMCA, because it's ridiculous and it's nuts on its own face. But it almost feels misplaced at this conference, because this is domestic law. We're not dealing with choice of law. It's a very different thing with the Echostack, where the other nation's law is trying to have their determinations apply within our country. But we could fix the DMCA, or how we interpret its power and the effect we give to just people who happen to be anywhere. But it's our law. Surely this is something that we could approach domestically, whether tweaking the statute, interpreting the statute, running through some of the jurisdiction questions about, if you send the takedown notice, how exposed are you to American jurisdictions? But we don't really need to consult international choice of law type questions, do we? Do we think that with harmonization and national treatment, do we think that's what brings it back in, where what Ecuador wants to do, or what an Ecuadorian citizen, forget the government, wants to do, where that should matter for the purpose of how we give the DMCA, the power that the DMCA gives rights holders? Should that matter? Or it just feels like this is a purely domestic issue?
I feel like that was directed to me, so I'll respond briefly. Briefly, and if I understand the question right, I think I look at it not as a theoretical parsing of territorial rights, although I acknowledge that that's a thing. I look at it as a practical risk calculation. And the practical risk calculation is, if I get sued in Ecuador after I got DMCA in the US, I want to show up and say, stop it, because I haven't lessened my risk globally. So I don't see being able to get an Ecuadorian, I don't see getting Congress, maybe on the right day of the week, to legislate something that binds Ecuador. And that, if I am pushed into the realm of the squishy questions of international comedy and the domestication of judgments and how we get a foreign law expert to opine on what fair use looks like in Latin America, though that is a level of reliability and messiness that I don't want to get into. I am deeply incentivized as a practical matter to just take the thing down, not want to go to Ecuador ever. And if I get a valid counter notice, now I'm super worried because they haven't waived anything. The waiver has to happen there where the sovereignty exists. So to me, it is not a thing that we can really, we can deal with consent to jurisdiction maybe as a matter of national law, because I actually think that Ecuadorians might not appreciate that as a matter of sovereignty. So I actually think once you get into these questions, like if people choose to use the DMCA as a global fast lane, they are opting partially into it, and we are stuck with the consequences. For me as a market actor, of just saying, like, I would like to get my liability to zero or as close as possible, and like not have to fly to random places to deal with it. So I don't think parsing it as domestic law solves any of those practical questions of like, can I go tell my CEO that we are not going to get sued in Ecuador?
And
make it worse for you?
Well, I mean, I would still like to not take things down that should not be taken down. I think the DMCA creates an ambiguity as to what a person thinks that they are doing when they send a DMCA notice. They are doing something based on the legal right. Go ahead, Corynne.
Yeah, I just want to add to that too. I mean, if you think about it too, like, so say you've got a site and they're posting a bunch of stuff commenting on Ecuadorian politics, right? Well, presumably there's people in Ecuador. I mean, that's not necessarily going to, I don't care about Ecuadorian politics all that much, right? But there's people in Ecuador. So like, we have a site that's concerned with Ecuador and Ecuadorian government, but then they're sending notices here to the United States. I mean, it surely ends up implicating, like or not, the rights and interests of people, from wherever the users of this site. It may be it may be a situation too where the person who is actually the writer isn't located here at all, right? They're just using Medium, right? So what if they wanted to send a 512 notice? Do they have the ability to do that? How would that work? Do they sue in a U.S. court? How does that all happen? I mean, I think it would be nice to think of this as purely just domestic law, but I think as a practical matter, I'm very sympathetic with Alex's concerns, especially too because I imagine they don't just confine it to copyright. They're probably using it as trademark complaints and all the, it's just people understand how to do it. And there's a website that shows you how to do it, so it's very natural that everyone just goes to it. But it doesn't really have the same sort of balance that we're supposed to have that we do have domestically to some extent.
So we're coming up on 2 o'clock, so if Jacob and Sally, if you guys can both ask your questions one then the other, we'll give the panel a chance to respond, and then we're going to have to wrap it up.
Okay. So I'm Jacob Rogers. I'm from the Wikimedia Foundation. And so my question, kind of following on from what we were talking about, is how you take some of these international issues and try and resolve that choice of law conflict domestically. So let's say you lose that Ecuadorian case, or Google loses the Equus Neck case, and then you still don't comply with it because they're in Ecuador, and then they come here and they come to a US court and they say, US court, enforce our Ecuadorian law. And what is the domestic resolution that we can try and seek at that point? Do they enforce Ecuador law? Do they say, no, that's fine under US law, so you don't have to do anything? Do we go back to this morning's panel and they'll order a geo-block just for Ecuadorians? Is that even like a US court remedy they can order? So that's what I'd like to know about.
And I think I won't take much time because my question is very similar to Jacob's. And as a way of brief background, I am an IP litigator from India working for copyright owners. And so this discussion that we had today is something that's frustrated our team for a very long time, because when there is not one jurisdiction where the owner is or the infringer is and another jurisdiction where the infringement is happening. When you look at, for example, movies that are being pirated online, there is the infringer who's sitting in another country, the server which is in a third country, and these aren't hosts like Amazon or Google or the ones that would be willing to comply. These are Gandhi and the internet service providers they don't care, they don't want to comply with it. So we've had replies coming back to us saying, we're not in your country, we're not bound by your country. So but it is infringement when it comes to India. It is work that was produced in India. How do you resolve that sort of conflict of domestic laws?
Just to respond to the initial question, I mean, this is certainly not my area of deep expertise, but I mean, it seems to me that the kind of issue you raised is really nothing new under the sun. I mean, there's many decades, maybe hundreds of years of sort of enforcement. The question of under what circumstances is it appropriate to enforce a foreign judgment? If a Saudi Arabian court issues an order on a contract dispute, there's probably a pretty good chance that an American court is going to enforce it. If they issue an order in a defamation context or a blasphemy context, we're not, because the courts here are going to look at whether it sort of offends fundamental notions of public policy. And in a contract law, I bet their contract law is actually pretty similar to ours. Their blasphemy law has absolutely nothing in common with our blasphemy law or lack thereof. I'm not sure. I mean, the internet really changes the calculus all that much in those kinds of issues.
So the one thing that I would say, I actually don't disagree with a lot of what Ben said just now, but here's where I think it gets different, and this goes back to the issue of upstream, downstream. So let's say I'm just a purely US-based company, and they actually have to come here to enforce against me. Okay, that's one set of circumstances. But what if I'm an internationally based company, like Google was? That's another set of circumstances. Okay, but what if there's something else? What if I'm an entirely US-based company, but I'm relying on service? I'm relying on a service provider upstream from me that is an international company that will be concerned about whether there might be some order might be enforced against them in another company. So I'm purely domestic. They should have to come to me, right, and enforce it, and then I can go to a US court and say, no, that violates the First Amendment or whatever, and it's not enforceable. But my upstream provider may feel very differently. And that's where I think the internet makes things different, because you can't rely on things staying domestic. And you may not even know, right, always who all your upstream providers are and where they're located and where they're vulnerable and where they're not.
Yeah, two quick things on that. One is I agree 100% with that. With all of the talk of data localization, I am somewhat pessimistic that we will be able to resist it. Data localization is happening through the consolidation of cloud service. To me, that is just a fact. When we get big enough to have our own data centers, we'll do what we want, I suppose. But that is a thing that I think is people are focusing at the legal choke point as opposed to the infrastructure choke point on localization. I think that is the wrong place to look. I think the second point, to agree with Ben, is that the domestication of judgment law is really, like, I disagree to the extent that I don't want to roll the dice, but you basically hire somebody to show up and say, like, the most awesome due process is American due process, and no other due process is like our process, so don't domesticate it. Like, that's basically the argument every time. And maybe they'll find that the blasphemy thing is not blasphemous enough, but by the time you get to the point of domesticating something like that, you're really in a very deeply leveraged position that you don't want to be in. So the incentives are not in a good place to want to keep speech up. And then the final 2.5 point of that, which I just think about sometimes, is that often in other countries, as a practical matter, you'll get takedowns that say, like, take this thing down for whatever reason it's blasphemous, it does different things that are domestically not cool. We in our system do not rely on courts for this. We rely on an administrative body that makes a determination that this is illegal and blasphemous and venal and many other bad things. I'm the administrator, I'm the panel, take it down, due process has been served. And then you can say, like, as somebody adverted to earlier today, is that court-like? Is that an administrative-like proceeding? And so these issues are also quite a problem if you're going to be respectful of the principles of comity, of what the body even is that is issuing a thing. Look at that.